Welcome to the Legal Learning Podcast. I'm your host, Jolene, and with the Legal Learning Center, I help prospective law students save $300,000 on law school. If you'd like to ensure you are remembering everything that goes into applying to law school, visit legallearningcenter.com for a free law school application checklist. Today's guest is Elizabeth Lippy. She's a trial attorney and a trial advocacy professor at a law school. She's going to explain why this is probably the most important class for every student, even if you have no interest in being a trial attorney.
Hi, Jolene. Hi, everybody. My name is Elizabeth Lippy, and I am the Director of Trial Advocacy at Temple Law School, also a professor of law there, as well as an owner of a business called Trial Advocacy Consulting and Training. I call it TACT for short, T-A-C-T. Thank you so much for having me.
Thank you so much for coming on here. I'm so excited. This is a topic that I think is so important because for me as a law student, I saw zero value in it. So I think it's important for especially prospective law students and even law students to really hear where the value is in this course or in this general topic, especially because I only more recently learned that at most law schools, it's an elective, whereas at my school, it was required. And so that is the only reason I took it. I wanted nothing to do with litigation. So I highly recommend everyone take this course. But Liz, first, why don't you tell us what is trial advocacy?
Yeah, I wish it had a very succinct definition, but it doesn't. So bear with me as I kind of try to define this. So trial advocacy courses teach the art of being a trial attorney. So the art of communicating in a courtroom and persuading the jury. The typical trial advocacy course teaches how to try a jury trial. So from start to finish in a jury trial, including voir dire in some classes, an opening statement, questioning the witness, both direct and cross-examination, dealing with objections and evidence and the issues that come up on the fly, and of course, closing argument. So that's basically your typical trial advocacy class, at least the beginners. So a lot of law schools, including Temple, have advanced courses that are focused on one skill or dive a little bit deeper, for example, into evidence and into objecting and how to respond to those objections. So it's the course that really prepares you to become an advocate in any forum, whether it be arbitration, mediation, a jury trial, which as given COVID has been somewhat less and less nowadays. But it's the class that has the practical application of the 1L doctrinal courses that every law student has to take.
I think it's also almost necessary to graduate from law school with having taken this course, just because how can you say you went to law school and not really have even practiced at all these trial skills? Again, even if you don't want to go into trial, I just think you have to at least say, I kind of tried that out. I did that a little bit.
Well, not only that, Jolene, but the bar exam is everybody's like kryptonite, right? We're all terrified of the bar exam, and evidence in particular is one of the major subjects that's tested. So a lot of my students, the light doesn't really click with regard to the rules of evidence until they put it into use. So not only do trial advocacy courses provide you with the communication skills that are necessary in a courtroom or in a legal forum like that, but I think that these courses also help you actually put into context some of the doctrinal lessons that you're going to learn as a 1L, and especially with regard to evidence. And it helps with the bar exam preparation when you actually understand the rules and understand the different subject matters that are tested.
Yeah, I know it really, really hit home for me. While I was studying for the bar exam, I was taking a study break and I watched The Rainmaker with Matt Damon. Have you ever seen that movie?
I actually, maybe like many, many moons ago, Jolene. I think we're dating ourselves here.
Yeah, it was, exactly trial advocacy. It was like, I think he was a recent graduate and he was kind of thrown into a trial and he was making all the evidentiary mistakes, all the objection mistakes. He made an objection and they're like, what are you objecting to? And he's like, I don't know, kind of a thing. But it's nice to kind of be able to do that in a classroom setting and really just go through all those motions in a safe space.
For sure. And I make a big point of that, right? So in a law school setting, as opposed to a real life setting when somebody's, your client's life is in liberty may be at stake, or if you're a prosecutor, maybe the government's, like the community's safety might be at stake, or if it's a civil case, millions of dollars at stake. There's so much more pressure in the real world. So in the law school community and the law school class, I always joke that, hey, nobody's going to jail. Nobody's going to get hurt. This is your opportunity to try and to get that individualized feedback from adjunct faculty members who have years and years of experience, to be able to actually learn these skills and learn what you're doing well, and then fix what you're not doing so well. And I will say one of the additional benefits for many trial advocacy classes is what I just mentioned, right? The people who teach them. So networking in law school is extremely important. And I'm sure you have many, many podcasts about it and talk about it with a lot of your clients and future law students. Being taught by a lot of the trial advocacy adjuncts creates a relationship with some judges, practitioners in the area, and the sky's the limit with the networking aspect of it, which I think people often overlook when you have these type of classes that are kind of electives in a lot of law schools that you can take.
I never really thought of an adjunct professor in that way. I mean, of course, they have a full-time outside whatever job in general, but yeah, I never thought of that as expanding my network beyond the law school.
Oh, it's a huge benefit because they want you to succeed. They want you as one of their former students to go back and say, oh, I had Professor so-and-so for my trial ed, and reach out and say, hey, would you be willing to vouch for me and give me a letter of recommendation? Do you have any connections at this office? You'd be surprised if you tap into that network, how willing they are to help you as a law student. So I think it's an amazing networking opportunity that's often overlooked.
Yeah, I think also trial ad, the class can be such a confidence booster. I mean, again, I was not interested, but I did really well in the class. And so it really just, I don't know, gave me a sense of security, a sense of accomplishment, even though I didn't want to pursue it. But then years later, when I ended up in a highly litigious trial, proactive area of law, I did have that just slight comfort that, hey, when I took the class, I did pretty well. So I should be okay. I might be okay.
Yeah, I mean, I'm not going to lie to your listeners and say that there are times, though, Jolene, that I'm sure you probably also felt like, oh my gosh, I don't know what I'm doing, right? So, there's the both sides of the fence there. You're going to get the positive feedback for sure. But our job when we teach this class isn't to just tell you everything that you're doing right. So there is an aspect of kind of constructive criticism that goes along with it. And sometimes it's hard to hear. And you need to make sure that you have an open mind. But again, as we already mentioned, that's a safe space. And if you're being told that there are certain things that you can try and do differently, what better way to do it when there's nothing at stake, except for maybe a grade? So a lot of trial advocacy classes, though, some law schools, including Temple, they're pass-fail. So you don't negatively impact your GPA if it's a pass-fail class and you put yourself out there and you try new things, as long as you do the hard work. And for those schools that actually have like a grading system for the trial advocacy classes, I think it's a grade booster most of the time. So it's a very subjective class, meaning I could come into the class with a ton of natural talent. And there could be another student that may not be a naturally good speaker, and they're not going to be penalized for that. You're going to necessarily benefit from the work that goes into it. And we as professors can see through the people who try to not do the work, right? The way that I personally score my students and grade my students is I want to see the improvement from the beginning of the semester to the end. So even if you're not the best speaker in the world at the first day one, are you listening to the feedback from me as a professor? Are you incorporating it into your next presentation? That's more important to me than somebody who's the best orator and best debater and speaker in the world.
That's great. And yeah, I definitely felt, I think, first of all, I think I took away confidence from that because I had no interest. So it was like, cool, I did that well. And any criticisms didn't matter to me because I wasn't going to do it again. So that's probably why my memory is like, I did amazing in there. But yeah, it definitely, was a nice break as well, because all of your classes are just you sitting there and, okay, today I get called on or whatever, versus this is actually you're standing up, you're moving around, or, and even if you know that day, maybe you're not participating, you're like your teammate is doing it or whatever, you're still, I don't know, an active part of the room instead of just sitting there.
I cannot like accentuate that even more than what you just did. So for me, 1L year was exhausting, difficult, a hard transition from college to law school. Like I had to think a different way. And there was so much reading, so much writing involved that it was like a breath of fresh air when I personally took my first trial advocacy class. Because I was like, this is fun. Like you actually get to then, like you said, participate, get up on your feet, ask questions of a witness, and deal with the things that come at you that you don't necessarily expect, right? I love dealing with the unexpected. Some of us might not, but there are still tricks and formulas and things of that sort to make sure that even you're even prepared for what you cannot prepare for. So yes, it's a huge difference from a lot of the doctrinal classes that law students take. And I consider it a breath of fresh air. It's so much fun.
Along those lines, that's exactly what happened to me. Was there was a theory on the case. My teammates and I, for this one witness, we could only come up with 3 questions. There's 3 of us. We didn't know how to handle this because normally we'd each go up and ask a handful of questions. So we said, okay, it's going to look stupid, but we'll each go up and ask 1 question each. And yeah, I mean, it feels dumb to stand up at the podium, ask a question and go sit back down. But we were like, how else can we do this? Right. And so that was our agreement. My lovely teammate gets up there and asks all 3 questions. And it's like, okay, now it's going to look like we didn't do the work. And I mean, I'm sure the professor knew, but like, so the professor asked us, do you have any more questions? And of course, my teammate says no, because we didn't. And I said, I have questions. Why did I say this? I don't know. I just didn't like sitting there. So I get up and I'm like, I have 0 thoughts in my head. I really don't know what I'm going to ask this person. And then I just started asking questions. And after class, the professor was like, where did you come up with this theory? And I wasn't even sure I had a theory, right? I was just asking questions. And I'm like, I don't know. These questions just came to me. And he's like, that is a theory that students only get once every few years. And I was like, oh, okay. So, it was
good
really
for you. And I'm not surprised to hear that though, because Jolene, like here you are, you're doing a podcast and you're asking people questions like me, right? So what this is a direct examination. Like you are asking me as your witness on the witness stand, the questions about your particular subject matter that you're interviewing me about. So I'm not surprised to hear that you had a natural ability to actually do that and ask the questions and have this crazy theory, or maybe not so crazy theory, that the professor didn't see very often. But it may have even benefited you to become now this podcast host, to be able to have that skill under your belt that you learned in law school.
Yeah, it definitely taught me to not be afraid to think outside the box, to not be afraid to just try things, and to not doubt myself so much. So when I spent 15 years in workers' comp, and sometimes I would propose theories on cases and people were like, that's not the law. And I'm like, well, how does law get made? We make the law. So you know what? I'm going to ask these questions, even though technically today it's not relevant for this case, but this case has been dragging out for like 10 years. If it drags out another 10 years, it might become relevant. And people are looking at me like, you're wasting time. Like, no, I'm not. I'm preparing for the future. So, but I've heard many times that I was good at deposition, and I used to doubt it. I was like, I don't know what you're talking about. I'm just an average depo taker. But again, I think it goes into the podcast. It's just a skill that apparently I think I've recognized now I do have. So.
For sure. Absolutely. And I think one of the number 1 skills that we teach in trial advocacy, believe it or not, is not just how to communicate, but how to listen. So listening effectively in a courtroom or any given forum, I believe, is one of the most important skills. And it's a hard skill, especially like when you're cross-examining a witness, which is my jam. It wasn't my jam in law school, but now that I've done criminal defense work for a long time, I love cross-examining because it's more of like me being the star of the show and asking the questions of the witness and trying to only get a yes or no answer. So with that, though, you have to be a good listener, because if the witness goes off track, or if your interviewee goes off track, then you're gonna have to listen and be like, oh gosh, what's my next question? Where am I going next? So believe it or not, one of the main skills that I think students take away from trial advocacy courses is the ability to listen, which applies in anything that we do as a lawyer. So client intake interviews, as you just mentioned, depositions, talking to your partner, especially as a new associate, being able to hear what it is your partners want and listen to the needs of your clients. I think it's an extremely valuable tool.
That's funny you said the client intake, because as soon as you start talking about that, I thought of a client intake where the insurance adjuster clearly wasn't listening to the full story. And this was a dedicated account of mine. So when the client got to me and retold the story, I was like, wait a minute. That's not in the adjuster notes. That's important. And that could change the entire way we handle this case. So yeah, listening it's 100%. Yeah, exactly.
Absolutely. And I just want to mention too, so beyond the trial advocacy class, what I personally do a lot of in law schools is train students for trial competitions. So I don't know if you're aware of the landscape, or if those that are listening are actually interested in being a trial attorney, but there are different fields, 3 different fields that are applicable to mock trial. So that's the jury trial system. Moot court, so that's like the appellate argument. So you would be writing a brief and then making the argument on appeal as if you lost the trial, or maybe you won the trial and you're defending the case. And dispute resolution. So that's more of mediation, arbitration. So if you're really interested in this particular field as a law student, there are advanced opportunities of competing against other law schools. It's this amazing experience. It's a small group, right? So I usually train about 4 students at a time to go and compete against other law schools across the country. And I did it in law school myself. I've been doing it ever since I graduated from law school from a coaching perspective. And it's the most rewarding and fulfilling experience that I had as a law student and now as a law professor. I absolutely love doing the coaching of these competitions.
I think that those things are more important, this is just my perspective, of course, than like journal law review, because you don't do a whole lot of research. I mean, you do some, but not a whole lot of research and writing. It's usually kind of concise and to the point, I guess, versus if you're going into a trial heavy field, you need those trial skills. Alternative dispute resolution. I mean, that goes across all industries. Now, how much you may use it just depends, but it's a great skill. And there's entire people who have that just as their career. They're just, the mediators and that kind of thing. And same thing, the appellate, there are attorneys who specialize just in appellate work. I just feel like so much more practical to what is out there or more broadly available to people to do. So
100%. And don't get me wrong, it's a ton of work. So is law review. And I personally was not on the law review when I was in law school. Funny story. I picked up, there was a write-on competition. So I picked up like the 5-inch packet of paperwork after 1L year was over and, was going to get started because we had 2 weeks to do the write-on. I picked it up and I was so drained after my 1L year that I threw it in the trash immediately. And I was like, okay, so that's not happening because I know myself and I'm gonna practice self-forgiveness and not do the write-on. And I'm gonna put all my eggs into the trial team basket. Thankfully, it worked out for me. And candidly, as an employer myself, I would be more interested in a law student who has that trial team experience or moot court or ADR experience than I would as a law review article writer. So it may differ in big law from everything that I see. I think that they may be more interested in you being on a law review than being on a competition team, but the experience that you get is like none other. And I think that many employers kind of look for that and are interested in somebody who is willing to put in that extra time.
I agree. I think that big law might be its own little basket there, but most industries want you to have some practical skills, some hands-on skills. And that's one of the biggest complaints is law school doesn't teach us anything practical. And yet trial ad is there and it is so practical. All right. So are there any major mistakes that you see from students in the trial ad?
Yes, a lot of them. So number one, I see that people are not as confident in who they are, and they try to become somebody else. And I was just telling the story yesterday to another colleague, even when I was in law school, right? My first tryout for trial team, I had in my mind what a trial lawyer should look like, right? Being a female trial attorney and however many umpteen years ago. And so here I am, I walk into the first round of the tryouts and I have my hair slicked back in a bun so that my hair is not in my face. I'm wearing my glasses so I look smarter, like minimal makeup, super conservative clothes. None of this is me, as you can see, right? So I go in and I do my tryouts, and then I get called back for the second round. And I was actually called into the dean's office, and I was terrified. I was like, why am I getting called into the dean's office before my next round of auditions? Like, what did I do wrong? So she was like, the director of Temple at the time was a male, and he asked her to have a conversation with me and told me, can you put your hair down? Can you dress a little less conservatively? Can you I see how you dress right now when you're just normally in a class. Why did you look like that? And I was like, what do you mean? You want to see the authentic, like you want to see the real me? I thought I had to turn into somebody else when I walked into a courtroom. And so, I did the second round of tryouts and I looked more like this, more like comfortable in myself. And I made the team. And so what I see from a lot of people is that you come into a class, you have a conversation with the student, and they're delightful, they're fun, they're energetic, they're themselves and comfortable. And then the moment they actually turn into lawyer self, doing a direct or an opening or what have you, they turn into somebody else. I'm like, wait, where did that personality go? Like, where did your you go? Yeah. So that's one of the biggest things that I see happening at first. And it kind of takes a while to get people to understand their true voice and to use that true voice in the courtroom setting.
Yeah, I've seen that in practice. I had a trial where my witness was very, very nervous, and in workers' comp, it's a bench trial, and we're kind of more like in conference rooms. So I try to tell them, like, it's a small room. We all just sit next to each other. I mean, there is the little bit of formality with, who speaks when and that kind of thing, but it's going to be okay. And I said, opposing counsel is very nice. So he's just going to ask you some questions and it'll be all right. Well, opposing counsel does have a deep booming voice, but it's a small room, right? We get in there and he starts to do his cross of my witness and just is attacking him, has this even bigger voice. And I just was like, who are you? Where did you come from? And I told my client you were nice, and he's accusing him of embezzlement. And this is a work comp injury. Like, you know what I mean? Like, it was just like, luckily I have my objections, right? Relevance. So yeah. But it was just like, who are you and why? It's so unnecessary. But yeah, it's, when I was in law school, my moot court opposite was, ex-military. So she was standing so rigid. And when they gave us our critiques afterwards, they were like, you can relax. You don't have to stand at attention. And like, she was full out. I have nobody recently in my family in military, so I don't know the pose. It's like the relaxed pose, but for military, which is not
so relaxed for us. Yeah.
So it was just like, yeah, you did look pretty stiff there. So yeah, I agree. That makes a lot of sense. Because especially if you do have a jury trial, you want people to find you personable and relatable so that it's a little bit more of a trusting relationship of maybe what they're saying is real. Maybe I should listen to what their side of the story is.
Well, absolutely. And if you're not genuine, then people can see through that, right? Like if it's natural for you to have that stiff posture because you were in the military, embrace it, so be it, right? But maybe you want to address it in the opening or something and just be like, forgive me, I stand direct because I was in the military for 10 years. Please don't hold that against my client. I lean into a lot of what I am at this point when I do jury trials. So for example, you can't tell with a Zoom and this, but I'm 6 feet tall without the heels. So when I wear my heels and I am courtroom ready, I'm like 6'4", right? Depending on how comfortable I feel in those heels. And I can be intimidating as all get out, right? And I know that going into a courtroom. And so I have to kind of lean into it and talk about it sometimes and just embrace the fact that I know that sometimes I'm going to come across harsh. And I don't mean to. It's just, I'm so passionate about this case. And it's so unfair that my client has been charged with a crime that he did not commit. So, I kind of use what I know people perceive me as to my benefit now, because I have leaned into who I am and I've learned that. Whereas I just think that people are a little afraid when they're in law school to put themselves out there. It's scary to be vulnerable. And that's a lot of people's fears in even becoming a trial attorney in the first place. It's like, that's scary. You see it on TV. I can't do Law and Order. It's not really like that anyway. But, I think that being vulnerable is scary no matter what the field, no matter what area of your life.
Yeah, it is. And then doing it in front of a public is, yes. And even if it's a smaller public, even if it's a bench trial, so there's no jury, you're still in front of these experts, and it can be very scary, to be yourself.
Yeah, well, and judges, I think, are even more intimidating than jury.
Yeah, because they actually know what they're doing. You know what I mean? The jury won't know.
Most of them.
Right. Okay. Yes. I was going to say, maybe not all of
them. Sorry, judges out there. I didn't mean that.
Yeah. But yeah, the jury, there's a lot of things that they don't know you're messing up on because, they've never maybe done this before. So yeah, there is a little bit of leeway there. All right. So if people want to learn more about trial advocacy, I know you have a Clubhouse room. So what is that Clubhouse room?
Yeah, so I have through my company, so Tact Trial Skills on Clubhouse. So it's trial advocacy consulting and training. I host a weekly Friday forum at 3 p.m. I've been a little inactive because I had some vacation time recently, but every Friday at 3, look for me. And we talk about some of the skills and necessary trial advocacy skills that are needed right now. The most pressing issue currently is post-COVID courtroom ready, to be honest with you, because it's a whole new landscape if you have to wear a mask in a courtroom, because there's so much, I think, that's lost in your advocacy. So that's actually one of the challenges that I'm overcoming currently, even with teaching trial ad at Temple, is how are we going to continue to teach everybody these skills when you're masked and you can only see half of somebody's face? But that's the reality of what we're looking at right now in post-COVID courtroom practice, particularly with the Delta variant. So lots of conversations on Fridays at 3 p.m. Eastern Standard Time. Follow me on Instagram. It's @TactLawyer. And I'm happy to give my email address out if anybody wants to contact me directly at elippy@temple.edu.
Wow. Thank you so much for joining us today. I really appreciate all your wisdom and advice.
It's been so much fun, Jolene. I could talk trial advocacy for hours. So I do encourage your audience, if you do have any other questions or interests, please don't feel hesitant to reach out to me. I'm all about making sure that our future lawyers are empowered. So thank you.
Before we get into my top takeaways, a quick word from our sponsor, Juno. If you need to take out student loans, check in with Juno first. Juno can often offer law students 1% to 2% lower interest rates than the federal government, and with no origination fees and oftentimes cash back as well. Visit advisor.legallearningcenter.com/Juno for more information. My top takeaways from this chat with Liz. Number 1, trial advocacy class trains you to be an advocate in any capacity. Number 2, trial advocacy is also the class with the most practical application. And this is also a class where you have a good opportunity to expand your professional network. That's it for this episode. A full transcript will be available at legallearningcenter.com/TACT, TACT. Next week, we're going to have somewhat of a part 2 to this episode. Rena Cook is a voice coach, and she's going to share with us how using your voice properly can sway juries and help our careers in countless ways. As always, if you enjoyed the show, please subscribe, like, share, leave a review. That just helps us help more people. Thanks.